Hello, my name is Jarrod Stephens and this is my video presentation for Professor Turner's Composition 2 class. The topic I chose to focus on for my paper is why voting rights should be restored for felons. I became interested in this topic for a few different reasons. The first is that it has been heavily debated the last few months, but especially in Florida, which caught my attention. The second reason was more personal in nature. I have an uncle who has had a felony conviction, and after talking to him, I discovered he has never been able to vote in an election. My hypothesis is that voting rights for felons in Florida should be restored after their debt to society has been paid. The current system keeps these individuals isolated from interacting as citizens, skews election results, and is in violation of their civil liberties and constitutional rights. I feel that my topic should be of interest to anyone who lives in Florida because, quite honestly, it is something that could affect anyone. I hope by the end of my presentation, people are more informed about the issue of felon disenfranchisement and the effects it has not only on the felon, but on their communities as well. The current system in place for restoring felon voting rights is flawed. Throughout my research, I noticed there is no uniform system in place to restore felon voting rights after they have completed their sentence. In fact, Florida is one of 4 states where felons permanently lose their right to vote. One statistic in particular stood out to me, and it was from Patrick Johnson, who stated, about 4.7 million Americans can't vote because of their criminal record, 1.7 million of whom live in the Sunshine State. Currently, the only way for a convicted felon to restore their voting rights is to go before a clemency board. I went to the Florida Commission on Offender Review's website and found the board is made up of Governor Rick Scott, the state's Attorney General, Chief Financial Officer, and the Commissioner of Agriculture. However, going before the Clemency Board does not guarantee voting right restoration. In fact, Governor Scott has approved less than 2,400 applications for rights restoration since he was elected in 2011. The number is significantly lower than his predecessor, Charlie Crist, who approved over 155,000 during his 4 years in office. Another fact to back up this point is the Clemency Board only has 4 meetings listed for 2018. These facts have led many felons and advocates for felon voting rights to claim the system is unconstitutional because it is purposely trying to prevent felons from getting their rights restored. There have been many arguments about the constitutionality of felon disenfranchisement. In the past, opponents have argued that the system was unconstitutional largely because it prevented African Americans from voting. Now, opponents of felon disenfranchisement argue that the system is unconstitutional because the guidelines in states such as Florida are too strict for most felons seeking to restore their voting rights. Not only does a felon have to wait 5 years, but the final ruling comes down to the governor. Many advocates for restoring felons' voting rights suggest this is unfair because the governor can refuse to restore rights to someone if they hold different views. One prominent figure who agrees is U.S. District Judge Mark Walker. Judge Walker has complain that the current system is too slow and favors felons who hold similar political beliefs to the clemency board. Walker cited a case where an ex-felon who was admitted to having illegally voted for Governor Scott had his voting rights restored while others were denied because their beliefs were different. Many ex-felons have even suggested they feel intimidated or too confused about the rights restoration process to even make a case for having their rights restored. This is seen by many as a violation of the 14th Amendment of the United States Constitution because it widely affects African Americans. Former U.S. Attorney General Eric Holder has asserted, throughout America, 2.2 million black citizens, or nearly 1 in 13 African American adults, are banned from voting because of these laws. Holder's point is important because it helps to explain how felon disenfranchisement skews election results against minorities and their communities. Not everyone is convinced felons should be granted voting right restoration. Some have argued felons should not be able to influence the law when they themselves have so easily broken it. They feel that the felons do not show the good moral standard needed in order to have the right to vote. In completing my research, I have noticed a good deal of support for changing the process for how ex-felons' voting rights are restored. Currently, Florida has suspended restoring any voting rights because of a disagreement between Governor Rick Scott and U.S. District Court Judge Mark Walker over whether the current system is constitutional. The argument will get even more heated in November when an amendment to restore voting rights to convicted felons is placed on the Florida ballot. There would be exceptions for murderers and sex offenders, but it would seek to restore voting rights to others. I do have questions about any other restrictions there might be beyond that. These new developments in Florida lead me to believe my hypothesis will turn out to be correct in the end, and the 1.7 million Floridians affected will be granted their right to vote.